Hi, I'm Paul Robichaux, a senior contributing editor with Windows IT Pro magazine. Today, we're going to be talking about Ediscovery in Exchange 2010. It's a really fertile topic. There's a lot to talk about, and there are a lot of misunderstandings out in the community about what Ediscovery is, who needs it, basically why you care about it. With me today from Sherpa Software is Marta Ferensbach, and she and I are going to be talking. Welcome, Marta.
Thank you.
She and I are going to be talking about some of the Ediscovery features in Exchange 2010, how we got the features that we have, what you can and can't do with them, and most importantly, what these features mean in the broader context of the market. With all the hubbub and excitement around cloud-based services like Office 365, it's interesting to look at how the requirements for Ediscovery have changed and are going to change into the future to support deployments where not all of your email boxes are necessarily going to be under your direct control. So to get started, I want to spend a couple of minutes talking about what Ediscovery is and why we have to have it. Most of the time when people hear the word Ediscovery, the first thing they think of is lawyers. And that's normal because, not to be impolite about it, but this is all the fault of lawyers. Discovery is a legal term that essentially means that you are turning over records about your organization or about your business operations pursuant to some kind of legal requirement. It could be a subpoena, it could be an administrative demand from an entity like the Securities and Exchange Commission or the Federal Aviation Administration. It could be part of a civil suit if someone's suing your organization for wrongful dismissal or wrongful termination or any number of other bad things that all involve lawyers. So the discovery process is really well understood in the legal community. There's a whole set of rituals, if you will, that go that set forth what you can ask for and how you ask for it, and when you're on the receiving end of a discovery request, what you have to do to negotiate certain things as being out of scope. Well, for a long time, Ediscovery was sort of unsettled, but in 2006, at the end of the year, the federal government, and it's funny because I almost said Microsoft released this, which would be a neat trick, but the federal government, the federal court system, released an updated version of what we call the Federal Rules of Civil Procedure, or FRCP. This is a playbook for people who are bringing suit in federal court. And it says if you're bringing a civil action, here are the requirements, here are what you may do, here's what you may not do, here's what you must do, and here's what you must not do. For every aspect of trial procedure, ranging from how you address the judge in the courtroom to everything. A lot of it is very boring and very detailed, not at all interesting to people who are not attorneys. But the Ediscovery piece is pretty interesting because it sets out what electronic records are, what you must produce, what you can try to negotiate not producing, and basically it sets out everything that you need to know pursuant to Ediscovery. So let's start off, Marta, by talking a little bit about FRCP and who it applies to. I mean, is there anybody that can, are you allowed to say, well, I don't think this applies to me because I'm a small organization or I'm a nonprofit or I'm...
No, I mean the Federal Rules of Civil Procedure is for federal court, but it's also used as the template for a lot of the state rules of civil procedure. Mm-hmm. So if you're involved in litigation, you certainly have to follow the rules of either your state or federal, depending on where your trial is being held. So from that point of view, if you're in a lawsuit, party to a lawsuit that is on the civil side, you do have this obligation of electronic discovery. There's several rules in there that specify for that. But in addition to that, it's not just about the federal rules or being in a lawsuit. As you mentioned before, when you are asked to produce data from the government, be it state government, local government, if you're under compliance regulations, even if you're doing internal investigations, something's happened within your organization, basic compliance, basic auditing, all this kind of falls under the umbrella of Ediscovery, although only a portion of it is actually regulated, which would be what you're going to trial. And of course, most businesses can be party to a lawsuit, and your obligation actually begins early. I mean, it doesn't begin if you receive a subpoena, it doesn't begin when you are party to the lawsuit. It actually begins when you suspect there might be a lawsuit. That's your obligation begins.
Interesting. I heard once a fellow argue that preparing for discovery after you've received a demand is like trying to learn to be a firefighter after your living room sofa has already caught fire. That at that point, if you don't start to plan for and respond to this before then, it's too late. You might succeed in putting out that particular fire without losing your entire house, but your sofa's gone, and probably so is your living room at a minimum. So would you say it's fair that to think of this in terms of something that you need to prepare for and that you need to be able to execute on, even if you don't have any reason right now to think that you're going to be the target of a suit?
Absolutely, absolutely. I mean, you have to be proactive in a lot of these things. In my business, I see a lot of people reactive. They get in, they get sued, and they're in a panic. Their everyday business processes are completely disrupted because what happens, I mean, if you think about it, the worst thing that can happen if you're not prepared well enough for Ediscovery is that you lose your core case. I mean, honestly, there are cases that have had adverse judgments against them because they've inadvertently modified data, inadvertently, or they may have done it on purpose, some people, or they don't know where their data is, or they have email that they thought they didn't have and the other party has it. All these things can happen, and it disrupts your business. It disrupts, the adverse judgment. What happens when you lose a lawsuit? How much is that going to cost you?
How much do you have?
Exactly, and especially when you're doing things like intellectual property or something like that. So yes, to be proactive about it means in the long run you're saving time, money, and stress. I mean, I think people don't quite understand the importance of not stressing out, not having this absolute panic, which is what a lot, especially smaller businesses, have when they have this. Because a lot of times they don't have attorneys on staff. A lot of times they don't have the resources, if you will, that larger corporations have to deal with these things. So I think it's essential, especially for the smaller organization, to have the plan laid out ahead of time.
That's a good point. I think also it's important to understand the FRCP has what lawyers call a safe harbor clause. And it basically, I'm not a lawyer, thank goodness, but basically what it says is if you are subject to a discovery requirement and you make a good faith effort to meet it, but you are missing or you lose some data due to routine conditions. In other words, if you're not losing data on purpose and you have otherwise tried hard to meet the requirements, that generally you will not be penalized for that.
To a certain extent. I think safe harbor, the problem with a lot of these rules is that you can read them two different ways. The one way is your very generous reading of it. The other way says that you have to have completely outlined what your routine business processes are. Basically says data that is lost during routine business processes should not be adversely against the litigant for that. However, as soon as you have notice of a lawsuit, not even notice, even when you suspect a lawsuit might be taking place, you must suspend those routine business processes. So that's where something like a retention policy comes in handy. So you don't, on one hand, as you said, if you're in good faith doing this in good faith, especially if you're negotiating in good faith and you're talking to the other attorneys in good faith, that will definitely be in your favor. But at the same time, you have to be proactive about your retention policy. You have to be proactive about a litigation hold in that particular case when it starts. So safe harbor can work both ways. It really is a double-edged sword.
So I guess that's further argument in favor of consulting an attorney as you go through this process of planning how you're going to execute a new discovery
I would say
strategy.
when you're planning, I mean, theoretically, again, you can do this all kind of at home and do it yourself. There's a lot of resources on the net. Our website, sherpasoftware.com, is a good starting point. Also, Sedona Conference, EDRM.net. These are great places to start. So at least you have an idea. But we highly recommend, I think anybody who's coming up with their plans and their processes, retention policies, litigation hold processes, should have at least an attorney, especially one that has a little bit of knowledge in this area who has done it before. They should bring someone in to consult. But even if you don't, make sure you at least look at your peers in your industry. Right. See how they have handled it. Look on the internet, go in the different trade groups, and bring it up as a discussion point. How have you handled a situation like this? Because you'll see a bunch of different stories, a bunch of different experiences, and you can learn from those. So even if your organization is very small, doesn't have the resources perhaps to bring in outside consultants or what have you, at least become informed, understand what the terminology is, and designate people to help you with this. And if you whoever's running your IT, whoever's running your business processes, talk to them about what you're learning, that sort of thing.
It sounds like this kind of planning is cheap insurance going forward that everybody should do, even if you're absolutely certain that nobody's ever going to sue you and you'll never investigate anybody, none of the things you talked about are ever going to happen. In Fantasyland, it sounds like becoming knowledgeable and planning just in case is a smart thing to do.
Yeah, and honestly, business processes, if you have good processes in place, you should already have these things there. I mean, even outside of Ediscovery, you should have a retention policy. You should have a policy, what happens, for example, if an employee is terminated. What do you do with their data? You know, is it sitting there for years and years? Do you have it in a place just in case they sue the company or come back for a different reason? I mean, these processes cannot just help with Ediscovery, but they can help your day-to-day business.
Right. That's a good point. So speaking of business, you know, Microsoft has been in the email server business for a while. Mm-hmm. And at the time they first designed Exchange, I think Ediscovery was, maybe far-fetched is not quite the right word, but it wasn't common because electronic records were so few and so difficult to get to. Now, we talked a little bit earlier in our kind of pre-video meetings about the fact that things that are in regular databases like HR systems or payroll systems, that data is usually not discoverable in the sense that you can't ask for a copy of the whole database. You might ask for, I want a record of all the salary things that are pertinent to this employee, for example. But you won't necessarily be able to just ask for an entire copy of the database. But the rules have changed over time, and so Microsoft has had to move from not having any real discovery features to starting to roll them in version by version. So in Exchange 2000, we basically had nothing. You know, there were no discovery features to speak of, really. Then in Exchange 2003, Microsoft said, well, okay, we'll give you the ability to take a database offline and do some things with it. I guess I shouldn't say Microsoft did that. That was primarily the work of third parties. But in Exchange 2007, that was really the version where Microsoft started to introduce features that we think of as being e-discovery related, mainly the ability to do searches from the command line of multiple mailboxes at once and then put the results into a PST file, along with the fairly primitive ability to put content into and take content out of PST files so that you could more effectively deal with them. But in Exchange 2010 now, you know, Microsoft has got a bunch of additional features. So I'd like to spend a few minutes talking about those before we start talking about how you can apply those features and sort of what they mean in the context of your organization. So the first one that comes to mind probably is multi-mailbox search. Most of the time when people hear e-discovery, the first thing they're thinking of, besides lawyers, so the second thing they're thinking of is, how am I going to get the data that I'm being asked to produce into a place or into a form that I can do something with? So let's talk about that for a minute. Clearly, it's really important to know what you're looking for in the first place. But let's talk about how you go from a request from, say, your legal department to say, find me all the mail that talks about Project X or Employee Y. How do you actually do that in Exchange? What is that experience like?
The first thing you do, you of course have to get the requirements. So we're talking from a person, it really depends on how you have Exchange set up. Do you have Exchange set up so that your legal or HR people, whoever is interested in the data, can do those searches themselves, or are you doing it from an administrative point of view? What Exchange 2010 has done really nicely is put in a very nice interface to do your multi-mailbox searches. In addition to that, they've also structured their indexing, they've structured a lot of different tools for litigation purposes. Litigation holds, retention policies, etc., are also inside the tool. But the focus of the discovery is the new interface with the multi-mailbox search, and it's actually quite nice. It has a lot of different features that hitherto were not there. You talked a little bit about PowerShell, which in my opinion was a bit of a nightmare, not being an administrator.
PowerShell's awesome. Wait a minute.
Yes, Paul.
It's an acquired taste, I guess we can agree on that.
And honestly, if you're not a technical person, and I don't think that it was very efficient, and worse than that, I mean, you know, you can struggle through anything. I think the biggest challenge with PowerShell-based searches is that they aren't as defensible as the new multi-mailbox searches for one main reason, and that is you don't have a strict audit trail. I mean, how many administrators know that they had to, you know, keep all the statistics of their search, that they had to keep what they searched, when they searched, how they searched it, that sort of thing, in case they're ever called upon to testify. The new features make it much, much easier. They have your audit trail, is what it's called, built into this tool. Mm-hmm. Now, there are challenges with the multi-mailbox search, no doubt about it. And the first thing is there's a lot of data that isn't in Exchange 2010. If you haven't imported your PSTs, if you're not using your personal archives, you have to make sure that you get all that data as well. In addition to that, you know, there's a lot of data in basic communications that's becoming even more involved in litigation. Now, traditionally, electronic discovery, people think email, but so much more of business processes electronically is done outside of that. Think SharePoint, think your social media, think your laptops, your cell phones even. These are all discoverable. Any kind of electronic entity where you have community, it's called electronically stored information. Just think about that. How many different places you store and use electronic gadgets. Right. All of them are theoretically discoverable. Hopefully your attorneys are smart enough to know, and there's enough, they have enough understanding of your organization that when they do the meet and confer sessions, this is the little meetings that they have before a court even begins, they outline what you can and cannot discover. And hopefully your attorneys are smart enough, and certainly as part of the process, you educate them where your data lies. But coming back to Exchange, we were talking about the discovery. It is a very nice feature. There's a lot of nice features in there.
So that gives you a way to be able to query your Exchange database. It has a limit of 25,000 mailboxes at a time that you can search, which, frankly, for most people, that'll be plenty. So you put in the search criteria, and the results go into something called a discovery mailbox, which is like a regular mailbox, except that it has some different permissions on it. And one thing I want to call out, because I think this is really one of the areas where Microsoft has made a big leap forward that a lot of people don't realize. Because of the way that role-based access control, or RBAC, works, then you can assign permissions to do a search to somebody who doesn't have any other permissions on the Exchange organization. So I can give my organization's general counsel or their HR department or some other group of people that I don't want touching my email server. I can give them a web-based way to do these searches and give them permissions to do the searches and see the results. And in fact, you can actually break it up so that one group has the ability to do the searches and a completely different group has the ability to see the results, but they don't cross. That's really powerful, because one of the big objections that people have to e-discovery implementation is saying, well, I'm worried. I don't want any one person to be able to see all this confidential or sensitive data. Now, I don't want to get into the complexity of how you make sure that your administrators are trustworthy and how you verify that they're only doing what they're supposed to do and whatnot, but being able to break things up in that way definitely makes it easier. Because that way the people who are supposed to be doing the searches can do the searches without dragging the administrators into it. And as an administrator, I really appreciate that. I don't want to be searching people's mailboxes to find out who was sending porn or who was stealing from the company or whatever the investigation or subpoena covers. I would really prefer to be as far away from that as possible. And it's nice to have that degree of separation built into the product. So for multi-mailbox search, that sort of covers the execution of a discovery request, but there's some other areas that touch on that we probably should also talk about. One you mentioned a minute ago is the ability to have retention policies. Now, those are pretty complicated. We're not going to spend much time talking about those here, but it might be helpful if you can just summarize real briefly what those are for, what they do, and how they play into e-discovery.
Right. Well, retention policies have been used for quite a while for more or less storage purposes, that people had large mailboxes and they couldn't support them on their systems. Storage has become relatively cheap, and that the reason for using retention policy for storage reasons has really decreased. However, as that has decreased, what we've seen is an increase in the number. In fact, is a requirement. I mentioned before the safe harbor requirement. You need to have good faith business processes, which means your business process is a retention policy. You have to define in writing how long you're going to keep data, and you have to have an active, auditable way of actually doing that. So the retention policy is basically saying, okay, I'm going to archive my email after a year, and then we're going to keep it for another year after that. Each organization has a different type of retention policies. Some organizations, law firms themselves, for example, are just as subject to discovery concerns as anybody else. They tend to keep their data a lot longer because their business process is very much tied in their sort of file systems / Exchange server. They end up using it as like a giant file archive. So they may have a different, because their business processes dictate that. So what you have to do is you have to tailor your retention policy to your organization. But you really should have one, though, because if you don't have absent a retention policy, everything is discoverable. You're liable for all the data in your system.
So that's a really good point. I remember a couple of years ago there was some flap in the news because Intel apparently, or Andy Grove, who I think either still was or had just left Intel's CEO position, basically said that Intel's retention policy was going to be to retain nothing, and that they were going to have a very short time horizon after which they would delete everything, because if that's your standard business process, then only data within that window is discoverable. Now, obviously, if you do that, you're putting a ball and chain, or you're handcuffing yourself, because there might be really good business reasons to keep data for 6 months or 12 months or whatever. And if you have a blanket rule that says it's got to go after, say, 4 months, you may be throwing away stuff that's valuable.
Yeah, and the irony is as well, it's always a balance, because on the other side of your retention policy is litigation hold policy.
Right.
And litigation hold, basically, once you even suspect litigation is taking place, you know, you terminate an employee, you're suspecting that something's going to come back. And definitely when you get a subpoena, definitely when you start those meet and confer sessions, you have to retain the data that you have. You can no longer delete it. You're no longer in the safe harbor. You're actually outside of it. And the FRCP is very clear about you cannot modify your data. You have to have it in a secure place. So you need to have a policy that says not only, okay, this is your retention policy, but how do we stop retention policy on certain custodians as well? So they go hand in hand with each other. So
well, let's talk about litigation hold then. It's probably we can't describe it as being like a super retention policy or a subset of retention policy, but normally litigation hold has kind of a specific meaning in the broader context of discovery, right? It means that when you are notified that you're under litigation, or when you know, once you become aware that you're a party to it, there's certain things you're not allowed to do. And there's a legal term for that, is what, spoliation of evidence, is that what they call it? So that essentially means you're not allowed to modify or delete records that would ordinarily be included in the discovery. If you think about Iran-Contra, right? Oliver North and his secretary stuffing all these paper records into the shredders, that's a really well-known spoliation of evidence case. And the same thing happens for electronic records, right? So litigation hold is designed to keep people from doing that. Would you say that's a fair?
Yeah, it's designed so that you have a repository of data, be it in place or a separate repository, where that data cannot be touched, where you have litigation hold in the very basic form is alerting everyone, all your custodians or whoever else is in your plan, that these people are now under investigation under litigation hold, and to secure their data and preserve it. It comes down to preservation is the technical term for it. So you're either going to preserve it by making a copy of it, putting it in a record store, and there's lots of tools that do that, or you can preserve it in place, which is the solution Microsoft has done for their Exchange 2010 implementation. So you have to, but it has to have a process around it. You can't just go to everybody and tap them on the shoulder and say, you need to hold this data. Although people have done it, and it's becoming less defensible now to do that, because people do make mistakes and they do delete things and they forget about stuff. And you've seen a lot of recent litigation that, judgments that have come down that really kind of frown on that process. They really want an overall straightforward process to
But I mean, wouldn't you say that it's fair that if you're using a version of Exchange, or heaven forbid Lotus Notes or something like that doesn't include litigation hold? I mean, what are you supposed to do then? Do you do as soon as you become aware, do you take a backup and then lock it in the safe? Is that
essentially
an alternative?
in electronic terms? I mean, what a lot of people will do is create a PST, for example, of the person's mailbox, and put that PST in, absent other tools. You can do these in Exchange. You can do any of these tools you can do with the tools that you have right now. So what you can do is you can use Xmerge, create an PST of that mailbox, and put that mailbox or that PST in it, what have you, on a secure drive. And you probably want to make a backup of that secure drive in case your media fails, because you do not have an excuse if you say your media has failed. There's actually a recent case where someone had taken a thumb drive, and they said the evidence on the thumb drive, threw it in the drawer, we have it, it's preserved, etc. Well, when they came to get the evidence off of that, thumb drives are not the best media in the world, and they couldn't extract the data. Even forensically, they couldn't extract the data from it. It had been, golly knows what happened to it. However, adverse judgment was set against them for spoliation of data. And this is the type of thing that can happen. So you want to be, not only do you want to be sure, you want to be doubly sure that you have the data.
So it's interesting, that's interesting in the context of the safe harbor requirements we talked about earlier, because the safe harbor requires not only that you make a good faith effort, but that you have to apply a reasonable standard of care. And I guess I would certainly argue that if you have something critical, putting it on a thumb drive and putting it in your desk drawer doesn't meet a reasonable standard for.
Well, the judge certainly didn't think so.
Yeah, I guess that's ultimately that's you have to convince the judge that you were trying hard. So in Exchange 2010, because we have litigation hold features, it's interesting the way Microsoft implemented it. So if you think about the dumpster, the deleted item retention folder, if you will, that we had earlier. Now there's something similar to that called the recoverable items folder. And when you delete an item, normally it'll go into that recoverable items folder and be recoverable by the user. But what happens when you have litigation hold enabled for a user? What happens to those items when they go in there
They actually have, if I'm not mistaken, a set of folders, and the place it's going in now is they actually have, and you probably are more in tune with the technical detail of this, but when you put something in litigation hold, it essentially says you cannot delete this. You cannot delete this at all. Putting a flag or in a separate folder, I believe is actually what they're doing with it now, and that is their way of holding in place, it's called. And anything that is with that person. Now, from the user perspective, the user might not see that. The user's not going to see what
when the
they
user deletes a message, it's interesting to point that out, because users who don't know about litigation hold, and frankly most of them won't, right? I mean, most of the end users in the world are not exchange savvy. If you enable somebody's mailbox for litigation hold, they can immediately go into Outlook and delete. They can try to get rid of all this stuff. But what's really happening is that instead of only going into the deleted items folder, it's also being safeguarded in recoverable items. And users don't have access to that when they're under litigation hold. So they can't see it, they don't see the folder, they can't touch its contents. Now, litigation hold also, it doesn't just apply to deletes. It applies to modifications. And so what Microsoft has done there is implement what they call copy on write. And what that means is that if you have an item in a mailbox and someone edits it, they remove an attachment or they edit the text of it or something like that, then a copy of the modified version of the item is also stored in recoverable items. So during a discovery process, you can go through and you can say, okay, here's the original item, and here are the 5 times that this person changed it. You can recover any one of those individual versions, and you have a log basically showing you the date and time and the responsible user for each one of those changes. So if you need to be able to prove that someone did or did not make a change or did not delete something at a particular point in time, then this litigation hold feature gives you that ability. And it sounds like that's fairly important from a legal standpoint, and being able to show that you were safeguarding what you were supposed to.
Absolutely.
Preserve.
I mean, even implementing litigation hold, it signs of good faith, etc. And also, all the litigation hold mailboxes or the recoverable items are discoverable under the multi-mailbox search as well, and that was very important, because it was previous versions didn't have that. You couldn't go into the dumpsters and search and things like that. So that is very, very important, and definitely a big step forward in Microsoft.
It's actually interesting from a technical standpoint too. We don't have time to go into all the nuts and bolts about how they implemented it, but it required a lot of changes to the store.
Yeah.
And I think it's possible that we may see some other interesting features coming out of that same technical work that they did. So one thing we haven't talked about so far is personal archives. And I know, Sherpa is heavily invested in the data management space, trying to help people. I probably shouldn't say get rid of PSTs altogether, but personally I'd be very happy if they all vanished. That's not always realistic from a business standpoint, but one of the things that Personal Archives is supposed to do is give you a way to take these PSTs that are scattered all around everywhere and bring them all back to your Exchange server and put them someplace where they can be backed up, where they can be managed, where they can be discovered. How do you think Microsoft did with that as a version 1 feature in Exchange 2010?
Not too bad, actually. They did a really good job. Well, with SP1, I should say, they did a better job, because the original version you couldn't have it on a separate data store, but now you can, which makes life a lot easier. They really did a lot of improvements, even in the discovery side of the house for SP1. A lot of the initial complaints I had about many of the features, they really did a good job resolving them.
Okay, well, good. We'll come back to that in a minute.
Okay, but yeah, no, I think they did a great job. I mean, you do have to be proactive about implementing it, though, right? I mean, if you have your PSTs scattered, we should probably say why PSTs are a challenge. It's mostly because you don't have any control over them. PSTs it's like any other individual file. You can put them anywhere, you can do anything with them. And once again, from a legal point of view, you are liable for them. The information that's there, if you have a retention policy, fantastic, but what if you have information on your PST and you don't have a retention policy that can touch it, you don't have any tools that go after it, you're still liable for that data. And people have them all over willy-nilly, and then they lose them, or they try to access them on the network, which is not a very good idea. So there's a lot of challenges with PSTs. And Sherpa Software does have tools that help take those PSTs, put them up into the personal archives, and then you have a one-stop shop. Your retention policy can be there, your litigation hold, everything on one place, which is great. It's fantastic. But you have to be proactive. You have to go out there, you have to get those PSTs, you have to put them in there. It's not going to happen by itself. In addition to that, you have to also think of at what point do you want to have your retention policy? If there's old data in there, are you going to take that up and put that in your stores, or do you want to start with a clean slate and do that, as long as you don't have litigation outstanding, of course.
It's an interesting way to think of it. Most of the time, when I talk to customers about personal archives, they like the idea of being able to say, okay, we're going to give our users large mailboxes, but we're also going to give them some place where they can put this old stuff that they think they need. As IT admins or as the IT department, we have no idea if this stuff has any business value or not. The users say that it does, And we would rather have it in a personal archive than, I was working with a customer a few weeks ago who said that they had an end user who had more than 80,000 items in their deleted items folder. Because when they were done with something in their inbox or in another folder, they would delete it. It would go in deleted items, and if they needed it later, they would go get it back from there. You know, as an exchange admin, that just makes me want to cry. I mean, that's a complete misuse of what the exchange store is for. But personal archives do give us a way out of that. You know, that customer could say, okay, Mr. End User, here you have this lovely archive, and it has a 20 gigabyte quota, and you can put all this stuff in it, and we'll back it up, and we'll manage it, and we'll maintain it, and you can search it. You never have to worry about losing anything. Now, would you please stop filing things in deleted items? That seems like a fair trade.
Definitely. And, you know, I mean, I've seen enormous mailboxes. You know, a lot of for attorneys, for all they should know better.
They're the worst about this, aren't they?
They're the worst. Executives and attorneys, I'll tell you what. And of course, they have the most power, if you will, in the organization. They say, well, I should be exempt from the retention policy. Well, okay, here's your personal archive. You'd be exempt from the detention policy, and we'll deal with that another time. Not necessarily.
No, that's an interesting question. Can you do that? I mean, can you say, okay, we have one tier of policy for our executives, and we have another tier for these people? Is that defensible in court?
Absolutely, if you articulate it. I mean,
so if you do, provided you do that in advance, you can't make up your policy ex post facto and say, oh, yeah, our executives had a separate policy.
Yeah, exactly. You really have to. First of all, as an IT person, I might fight back. You know, when you're creating policy, you really should create it with not just your IT people, your business people, but also your legal people as well. They should all be involved with creating the policy. But if it comes down that the executives have a separate retention policy, just make sure it's written down. Make sure that this is how we do it. This is their retention policy, and you have to stick to it. But as long as you have it articulated, that will cover you. It definitely will cover you.
Okay, good. So it sounds like the name of the game, sort of, to this whole process is figuring out what you're going to do, creating a policy, and then doing it, and then verifying that you actually have done it or are doing it.
And keep in mind, some organizations, financial services organizations, for example, have compliance regulations because. To make things a little more complicated, if certain SEC regulations say that all brokers need to keep their email for 5 years, I'm not sure those are the exact terms, but they have to keep their email for a significantly long amount of time. They obviously are going to have a completely separate retention policy, archiving system, everything else than the secretary in an organization. Right,
but to avoid scaring people, we should probably point out that if you're in an industry like that, the odds are really good you'll already know it. If
yes, one hopes that if you don't have that in place already, there's going to be severe challenges.
Right, so there's not a huge risk that you're going to wake up one morning and find out that there's this whole regulatory regime that you should have complied with that you didn't.
Yes, one hopes you're.
Unless you're in Europe, I mean, then.
That's a whole other story,
That's a whole completely different story.
Yeah, I mean, that's one thing with multinationals. I mean, even if you're a small organization that's doing business with organizations in the EU or other jurisdictions, they have completely different privacy laws than we do. And what we're talking about today very much is based on the United States legal codes and things like that. Canadian legal codes also a little bit different, more towards the American model than the European model, but there are enough differences there. And every jurisdiction is a little bit different. Your state jurisdictions are going to have different, each state has different jurisdictions and different sets of laws for civil procedure. Now, most of them do use the FRCP as a template, but they all have little tweaks. So you really do have to be aware of what it is in your jurisdiction. And of course, New York City is going to have it different than, say, Fargo, North Dakota, or South Dakota, actually. Than the other ones.
Okay, so this goes back to what you were saying earlier about being prepared and sort of knowing the terrain that you're operating in. You need to know what the applicable rules are in whatever court systems you have to do business in. Certainly the federal district courts, but also it sounds like the court system for whatever municipality and state that you're in. Okay, so we've talked about the Exchange 2010 features. I didn't really want this video to be all about the features because if you want to see how the features work, if you want to push the buttons, there are lots of ways to do that. The documentation for Exchange 2010 is a huge improvement over what we've had in the past. It explains pretty much everything you need to know about how these features work, which buttons do what the pros and cons from a technical or an implementation standpoint are of the features. But I want to talk a little bit more about putting these features in practice and how well they work in practice and sort of what you need to know and be aware of and watch out for if you're trying to use Exchange 2010 as a means to implement these e-discovery requirements we've been talking about. So I guess the first thing that comes to mind for me, because I think multi-mailbox search as soon as I think e-discovery, is the importance of making sure that you've identified a couple of things about searches. Under what conditions are you going to do them? So that covers things like who has the ability to ask for them. Who do they ask? How do they ask? I always tell administrators that if anybody comes to you and says, hey, I need you to search this mailbox for this or that, get it in writing and keep a log of the things that you were asked to do. Because at the end of the day, and correct me if I'm wrong, but it seems like if you are acting as an agent of the company, if somebody has an issue, or if they have a beef with the way that you did the search or the fact that you did one at all, then it's certainly possible for them to force you, or for them to drag you into the law engine.
Yeah, just remember, what you do as an agent of a company, you can be called to testify upon or deposed on what you're doing. So it helps to keep a very strict chain of custody, audit log, who asked you what, those sorts of things, because you are, in the end, responsible for what you're doing. And especially if you think there's something shady about it. If it doesn't, like this might be just a person, oh, don't tell so-and-so about this. It's one thing not informing the end custodians because they may be, involved in an internal investigation, what have you. But it's a completely different thing if you don't want to keep it. If you want to keep it from the VP or something like that.
Right. Come do this search. I'm going to ask you to do this search, but don't tell HR, don't tell legal. That ought to be something that would
exactly. You certainly should.
Be a warning.
Get it in writing. A lot of times people have authority over you, so be it. But you should be able to get information in writing to cover your back. I mean, that's what it comes down to. Because you will eventually, essentially, are liable for it. You might have to testify about it. So under the bright lights and the glare of an opposing counsel, which, believe me, nobody wants to go through if they don't have to.
Lots of people like watching movies about courtroom drama. Most people don't like being in them. So.
No, you want to avoid that at all costs. That's for sure.
So for multi-mailbox search, first thing is have some parameters around how the searches are going to be executed. My experience with a search console has been you don't really need a lot of specialized training to be able to do the search, although it's helpful to know some of the things that Exchange does and doesn't index. We talked earlier about PDF files. Now would be a really good time for me to say that I'm not a huge fan of Adobe's software from a security or usability perspective, and I should get that out in the open. But Exchange doesn't ship with the ability to index PDF files by default.
Yeah, I think that's a bit of a weakness because a lot of data these days are in PDF. I mean, as much as you might not care for them, and there's definitely challenges with them, it's a de facto standard.
Sure.
And because of that, you really have to have some requirement within your organization that you're able to search them. And if you don't search them and you don't know that you can't search them, that's a big thing. And one of the things that they don't advertise up front, but if you don't have the filters installed to do PDFs, then you're missing that incredibly large trove of data. And even if you do have them, as you kind of alluded to before, a lot of PDFs aren't searchable. They might be image only, they might be partly image, or they might be encrypted, which again the iFilters don't get around.
Well, so in my experience, the big problem with searching PDFs is that there are PDFs that are generated by Adobe's own software that Adobe's own iFilter will not read. And so it's not because they're image only or anything like that. It's just because there's some combination of the way, because in fairness, Adobe has got, hundreds, well, maybe not hundreds, dozens of products. They can generate PDFs. And there's some combinations of tools that generate them and the way the filter reads them that don't work very well.
And there's default encryption on PDFs that are created by Adobe software, and that renders invalid a lot of the machine readers, so the machine text readers that are out there.
But more broadly, I mean, there are lots of other data types that are not included in the default filter set that Microsoft ships. Now, they partially work around that by, there's a separate set of Microsoft-provided filters that can index a number of file types that are not included with Basic Exchange. But you still have to know to go out and get those filters and install them. And then there may be other things. We talked about CAD data earlier as being a great example of something that's really hard to index well, and that you won't be indexing at all. So you have to know whether the things that you're trying to search are actually, whether you're going to be including all the things that you think your search should catch.
And I think what the important part is, it's not obviously it's a challenge that you can't search these things, but you have to be aware of them. You have to know ahead of time what you can't do. And you have to inform, if you're an IT admin, inform your legal counsel, okay, well, we're going to do this. This is the search. These are conditions. But here's what we cannot search. How do you want to handle these exceptions? Because one of the nice things about Exchange 2010, they do give you a list of exceptions, things that weren't able to be indexed, things that were corrupt or challenged in one way or another. You have this list of exceptions. What do you want to do with it? Because that is just as important as the actual results that you're getting. Because based on other criteria, they might want to actually produce that, and they might want to actually review it manually. So, that's something you have to, again, the communication between IT and legal, both ways, you have to let them know that can't be searched for one reason or another. So know the limitations of Exchange as well as the benefits.
Now, one thing you said earlier reminded me, I want to bring up the fact that in Exchange 2010, because it's integrated with Active Directory rights management services, you can actually search rights management protected messages. Those are included by default in searching because the system can get what the RMS folks call a use license, to be able to open that document and index it, and because it's indexed and it's searchable. But of course, encrypted mail, if I'm using SMIME or PGP or some other encryption system, those messages are obviously not going to be included in the search. But I mention that because as people, the value of deploying rights management is great, but that's a concern that a lot of people have when they deploy it. It's okay, unauthorized people won't be able to read this material, but will I be able to read it when I need to? If somebody protects a document and leaves the company, if I want to get to it on a mobile device, if I have discovery requests. So I thought it was important to hear out that you could still see those things.
The one thing, whenever you deploy a new technology, you really should be consulting with your legal department to make sure, or at least unless you're knowledgeable yourself, can we search it? Because for all the business case benefits that you get, you also have challenges as well. And one of them is electronic discovery. And because it is a fundamental requirement from a legal point of view that you are able to search these, you always have to take that in consideration when deploying new technology, because there's no excuse. Well, we put a new system out there, whatever it happens to be, and too bad. You're liable for that data, and you need to search it.
Okay, so litigation hold. I mean, what do you need to be thinking about if you are? It's not something you implement, right? It's a feature when you need it. You turn it on the mailboxes you want to protect.
Well, you definitely need to have a process in place beforehand. Okay, what triggers a litigation hold? Who can trigger a litigation hold? Is it the certain personnel? In other words, you have to know ahead of time who can issue one. And then you have to know, okay, when a litigation hold is implemented, what do you want to do with it? Now, in Exchange 2010, they do make it pretty straightforward, and if you have clear notice of it, you can choose your custodians, put the litigation hold. The challenges really are outside of Exchange 2010. Okay, how far-reaching is this litigation hold? Is it on the file servers? Is it up in SharePoint if you have that? Is it on those local PSTs if you haven't imported them? How far-reaching is it? Do you need to copy that person's laptop at the time of the litigation hold? So these are all things that you need to put as part of your process. These are the steps you need to do.
And a lot of those have nothing to do with Exchange, right? I mean, if you're talking about having to image people's laptops or grab data from their mobile devices, or inventory all the flash drives or removable media they have, clearly there's no magic button you can push in Exchange that'll do that. Exactly. Which is too bad. Maybe in the next version
they can have the master
yes.
console.
Actually, in Exchange 15, I hear there's going to be a new "Do What I Mean" button.
Yes, exactly.
And you just push that, and it'll take care of
I'm really looking
for
for the telepathy feature. That would be very nice.
That'll be in E15 SP1.
Okay,
yeah,
that's good.
We're getting that. Okay, so litigation hold is much more a process issue than it is an implementation issue on the Exchange side. Retention policies, we could spend hours talking about the mechanics of implementing those, so I don't want to jump into that particular tar pit.
Well, the one thing I want to, there's so many resources out on the web these days that people can look at for creating policy, for implementing policy, examples out there. I mean, I encourage people, just do some research on it. Spend, an afternoon or something going out there, seeing all the different things out there. It's not as scary as it seems. Yes, the thunderous, you must have a retention policy, but it actually is pretty straightforward. A lot of companies do it. Look at examples of people, your peers, etc., how that's done.
Okay, so when you say that, though, that brings up something, and this doesn't really have anything to do with Exchange, but I think it's worth touching on. So if I talk to my peers and come up with a policy based on what they tell me, how do I know it's a good policy? I mean, how do I know that it's going to protect me?
Practice. Seriously, what I would do is run a drill. Run a drill that, with your attorneys. I mean, not everybody has in-house counsel, but you probably want to spend a few of those billable hours with the attorney and discuss what you're planning on implementing, etc. To go out there. But how is it a good policy? That you are able to run it. So actually run it in place. Say, okay, let's say we got sued and these 5 people are our key custodians and we need to implement the retention hold.
Oh, right. No, I mean, I get the idea of practicing like you would for disaster recovery, and I think that's really sound advice. But is there anything you can do ahead of time to make sure that your policy or that the results of your policy are not going to cause you trouble when they go in front of a judge? I mean, should you have your policy reviewed? I mean, it always is a good idea to have your attorney go over your policy, but sometimes the attorneys don't understand it. I think what it comes down to is, are you, as the IT administrator, confident that you could go in front of a judge and go through your retention policy and say, this is why we do it, this is how we do it, this is where it's being implemented. The other thing is that you want to make sure that when you have litigation hold, retention policy, etc., that you're able to keep that data in its pristine state. You're able to preserve that data as it was. And to do that, you probably want to check the data again during those drills and go back and say, now, has anything changed, between this file here and this file there? Hash it, whatever happens to be. That's some of the ways. But in a lot of ways, I'm kind of running around the question a little bit because it is a challenge, because you don't really know until you're actually in litigation, because
there's a lot of different things that go along with it. And the best thing is just audit it, audit your policy, audit your litigation hold, and realize that just about everything is discoverable. So just make sure that your process covers all of that.
And I guess the old advice about not putting anything in an email that you wouldn't want to see on the front page of the New York Times, that's still pretty important.
And they have a number of tools that are proactive tools that are tone checkers, for example, or they have stuff that will actually check for certain keywords that you're using.
Yeah, or I like mail tips a lot because it's an unobtrusive way to tell the end user, hey, you're sending this to 5,000 people. Did you mean to do that? Yeah. Hey, you're sending this to somebody outside the company. Are you sure that's a good idea?
They have compliance tools out there that will scan certain key terms for or patent numbers or things like that, whatever happens to be for confidentiality or for proprietary or things like that, that will actually stop these emails from leaving the company, that sort of thing.
Right, you can do a lot of that with the transport rules that are built into Exchange 2010, which is I love transport rules because it's like having a bucket of Legos. You can build lots of different things with them, and you have a lot of freedom to experiment.
And I think the key is that with your transport rules, with whatever you're putting in place, I'm going to come back to it, be proactive. Know that you have to put them in place. It doesn't help if you put that together after all this confidential data has left the company. So again, look what your peers are doing. See what industry you're in order to kind of be proactive about that.
I guarantee you right now that there's at least one person watching this who just heard you say, see what your peers are doing, and they're thinking, well, I don't care about any of this stuff because I'm just going to go to the cloud, right? Like Microsoft does in their commercials. So what's up with that? I mean, what do you think the impact of Office 365 and other cloud-based solutions is going to be on how we do e-discovery?
I look at it in two different ways. I mean, from a business process point of view, cost-benefit analysis, the cloud is wonderful. I mean, obviously, it takes a lot of the stress and strain off of especially small businesses, their IT department, and definitely has cost benefits. From the side of litigation, from the side of e-discovery, it is a challenge, I think, for organizations. Mostly because you have lost control of your data. Now, it depends. We've talked a little bit about the mixed mode environments where some data is kept locally, or maybe they control their own cloud environment. That's a little bit different. You have control over your data. You can do whatever you want with it, theoretically. When you are going to a third-party solution, however, I think is when the challenges start to come in, because there's a number of areas that really are not covered by basic deployments. And unless you're very, very clear when you negotiate your SLA, you might not know that it can or cannot do certain things. The perfect example is searching your data. Just from the very beginning, the key core competency of collecting data based on certain types of keywords, that's what I mean by searching data, retention, litigation hold. How is it implemented in your third-party vendor? And if they cannot clearly articulate that and clearly tell you the steps that you need to take when a litigation comes up as the IT admin, then there's going to be a problem when an actual case comes up. So even before you sign that agreement, you want to go through them. Okay, now how would I go ahead and go about putting a litigation hold in? How do you implement retention policy? What are your data destruction policies? How do you back up your data if they back up their data? That sort of thing. All these types of things, stuff that you would have internally in your organization covered by policies out to wazoo, you have to make sure they're doing the same thing. And more to the point, not just that they're doing them, that you understand what they're doing, because in the end, you might not have physical control of that data, but you do have legal liability for that data.
That's a really good point, because it's still your data. Now, the hosting provider, Google and Facebook, and some of the other internet-oriented companies are notorious for this. The hosting company or the hosting provider may claim ownership of the data.
Exactly.
But what that means normally is that they have the ability to do with it what they want to. It doesn't mean that it's not like a barrel of hazardous waste. If I give you a barrel of hazardous waste, it's yours now, and it's your problem. On the other hand, if I divide it into two barrels and I keep one and I give you one, then we both have a problem, and that's the situation we're in with these cloud systems. That I can still be responsible for the contents of that data if someone is misusing one of my systems, if they're harassing or stealing or you name it. But also I'm responsible if I am required to produce some of that data and I call my hosting company and say, I need litigation hold for this user, let's say. And they say, oh, sorry, we can't do that. Or we turned that on, and then in the event when you get ready to do a discovery, there's no actual data there. The judge is probably not going to accept you pointing the finger at your hosting company and say, oh, it's their fault.
No, and there's case study out there already, cases that have been decided that no, it comes down to the company is responsible for their own data.
That's a very interesting area that I'm going to keep an eye on, because If the safe harbor exemption gives you some protection against routine business operations, then it seems like you ought to be able to make the argument that if you're moving those routine business operations to somebody else, that your company is acting in good faith. And if the hosting company is incompetent or careless or whatever, why should you be punished? That's not going to fly.
Nope, sorry, no.
That's why I'm not a lawyer.
Due diligence is due diligence on your part that your data is up there, is being hosted. One of the more interesting cases, this is even before the cloud, is backup. You say, I have backup, this is my backup policy, here's how it works. What if you can't access your backups? That's not going to excuse you either. Now, sometimes backups, of course, are covered under unreasonable, but when you have your data up in a cloud, it's not unreasonable to expect that you can get your data back. So believe me, it's not going to fly, and it hasn't. I mean, there's cases out there of third-party providers or what have you. People contract out work to different things they expect it being done. It's not an excuse if it's not done. You are responsible for that data. It comes back to that. And keep in mind that your third-party vendors can also be subpoenaed for the data. So you might be subpoenaed, but so can they, completely outside of your knowledge. So another thing you want to make sure with your third-party data is that you are notified when they're subpoenaed for someone to collect your data. Because if you're involved in a suit or a government inquiry, what have you, you'd like to know about it. So there has to be a process on both ways. And
I'm guessing that it would look badly, it would reflect badly on you if the data that comes back from the hosting company and the data that come back from your subpoena don't match. I think that there have been a couple of high-profile cases where Company A and Company B were involved in a suit, and Company A was able to say, okay, we have these emails from people at Company B that did not show up in discovery requests from Company B, so it gave the appearance, at least, that they had thrown those away or that they had spoiled that evidence.
Exactly, and you can never tell, it's very challenging to tell whether something's done in good faith or if it's done on purpose. So when you have a case like that, how are you going to go to the judge and say, whoops, sorry? No, you really have to have your ducks in a row on that one. And I think another really key area that you have to be aware of here is that the jurisdiction where your data is being hosted might be different than the jurisdiction where you reside.
That's a good point. One of the things Microsoft has done that I think is really interesting is they have defined, or they've publicized, I guess, where their data centers are. And so they make it known to customers that if you're in one of these geographies, then your data is going to be hosted here. And if you're in one of the other geographies, most providers don't do that. I mean, for example, if you ask Google, where's my Gmail data being hosted, they're going to, number one, if you could find a person to talk to, which you can't, but if you could, they're just going to laugh in your face. They, assuming they know, which is not a given, that's not something that they routinely disclose even to their business customers. And I think the same is true for many other hosting providers. Yeah,
and the other thing you have to keep in mind when you're having a hosted provider is a lot of these discovery, litigation, hold, etc., they're considered additional features. So you might be paying more for them. And just be aware that the basic deployment of your cloud-based offering might not have these by default. In addition to that, you also have to carry or check for things like, for example, what happens if the system is down? How do you get your data? What happens if you didn't pay your bills? Does that mean that your data is no longer accessible to you? What happens if you leave the company? You decide that third-party hosting isn't for you. What's going to happen to your data then? Are you going to, do they keep a backup that they give to you? Those kinds of considerations.
It's interesting that you say that too. We spent a good bit of time talking about that at the last Exchange Maestro event that Tony Redmond and I put on in San Diego for Windows IT Pro. And one of the things that we sort of evolved into as part of our discussion is that typically, these cloud services are usually sold with 36-month contracts. And so along about somewhere between month 18 and month 20 or 22, you ought to be making a decision about whether you intend to renew that service or not. That's far enough into the contract for you to have an idea of whether it's a good fit for you or not, but it's early enough on so that you can start the work of figuring out how am I going to get all my data out and do it in a way that doesn't disrupt my business operations. Getting into the cloud's easy. Right? Getting out of it can be very difficult, and it makes sense to start planning for that in advance. And that brings me to something else that we talked about earlier that I think is important to touch on as we close. The whole concept behind best practices in the space both of e-discovery and of hybrid operations in the cloud and lots of other things that surround Exchange 2010 SP1. Microsoft has a really long tradition of, internally, they call it eating their own dog food. And of course, they had one CIO who famously wanted to call it something like eating your own ice cream because he thought that sounded more appetizing. But the point is that Microsoft uses their own technology, and they come up with what they think best practices are, backed by data that they generate from the way they do business. But they're unique in a lot of ways. They have a large number of mailboxes. Their users tend to be very heavy mail consumers. And so they design things in a way that makes sense for Microsoft and for other large companies like Boeing or Ford or Chrysler or Daimler or other companies of that same ilk. But what we see over time is that when Microsoft releases a product, they'll say, here's what we think the best practices are based on our operations. And then you'll see, maybe fragmentation is not the right word, you will see multiple sets of best practices evolve in the next 12 to 18 months as companies in different verticals and of different size start to decide what the best practices are for what they're doing. So where do you think we are in terms of best practices for e-discovery with Exchange? Is that settled, or are we still kind of trying to figure out
I think it's still evolving because, as you mentioned, the larger organizations do have a completely different threshold than a smaller organization is going to have. And a lot of organizations haven't yet merged to Exchange 2010. They've taken a wait-and-see attitude. They're waiting for those best practices. They're waiting to see how the implementation is. I think some people are a little bit scared off with maybe Exchange 2007. It wasn't quite what they wanted. They're wanting to see how widely adopted Exchange 2010 is. And it is. I see a lot of people who have migrated to it, and it definitely is with the archiving that they put in, a lot of different features that they can use one-stop shop for, essentially. However, especially in case law, so I'm looking from the point of e-discovery from that point of view, you're usually 2 or 3 years behind because you're looking at data 2 or 3 years ago. And so a lot of people haven't had a chance to use the newer features of the Exchange 2010 to see if that fits into their process because they haven't been asked for that data yet.
Okay, so if that's true, and that's a little scary when you think about having that kind of time lag, but if that's true, then let's say that a customer, they were an early adopter, they jumped on and drank the Kool-Aid and deployed Exchange 2010 last year. So they're on SP1 now. They get sued in May 2011. The data that they capture right now pursuant to that discovery may not actually come before the court or be a factor in that case until, say, 2014 or thereabouts.
Now, you keep in mind that there's a lot of different motions, a lot of different things going on between now and then. But what you're really looking at is that the case now, so let's just say you're being sued now, they're looking at data from something that happened in 2009. So that's where you get the timeline.
Okay. So there's two kinds of lag, right? You may have to, in 2011, you may be asked to produce data from, say, 2009, when whatever the bad act that you're trying to investigate or you're being sued about came from. But then that data may not be used in the case in 2011. It might take some time to percolate through the court process.
So you have to make sure that you have a process in place to deal with your backup data, to deal with your data that you didn't migrate. Let's just say a lot of people just start, starting Exchange 2010 from here on out, and they might not be migrating their data in. You're still liable for that data, just because it's not in your current Exchange stores. Maybe it's in those PST files we talked about earlier that are scattered on your system. So I think that the key is again, preparedness. Be prepared. Know where your data is, have a data map, get a good idea of where it is. But the best practices we talked about a bit earlier really depend on your industry. It really depends on your vertical. You had said before, what Microsoft designs its best practices for might not be ideal for that small 50-user company, 500-user company even. So, try and get a good read on what you're going to need and develop your own best practices around that.
Okay, good. So I see we have just a little bit of time left, but I have a question I've been dying to ask you this whole time. If you could ask Microsoft to put one feature in or take one feature out of the next version of Exchange or around e-discovery, what do you think you'd ask for?
Export to PST as part of the process. Right now, when you have to, so it's great, you search your data, you put in your discovery mailbox, you can do some review in there, you can do all these little tricks and features. There's nothing in there that allows you to export that mailbox from, if you are, now PowerShell, obviously you have a little bit of a challenge.
Yeah, PowerShell.
Yeah, but it's, the goal of Exchange multi-mailbox search is that the IT admin is not the one doing the search. It's your HR person. So they really should have an ability in those rules that they have to be able to export them easy. An easy export to PST, usually MSG, depending on what system that they're doing. And it should be seamless. It should be seamless for the user.
So you're saying that there should be a checkbox or a button that you push as part of that mailbox search process. It says when you're done, would you want the data in the discovery mailbox with a copy in the PST or just direct to the PST?
Oh, you want a copy of it, definitely. Now, it depends, again, on the process that the person's using. They might be doing some review inside the discovery mailbox. They might be tweaking it for this, that, and the other thing. But you should be able to have it as an option. And whether it's in both places, there's no reason you can't have it in both places. Easy export to PST. And the Unicode PSTs as well, not the older style.
Well, of course.
Yeah.
Nothing but the finest.
Yes, exactly.
Well, that's interesting because sometimes when I ask people that question, they ask for features that would be very difficult or prohibitive, or there's some good reason why Microsoft would never do that. That actually sounds like a pretty reasonable request.
Yeah, I don't understand why it's not there. I truly don't, because it's something that you need to have something produced. You need production to have that. And usually, when you have HR, you have your attorneys or what have you. They have other tools for review. It's always great to spot check your results and things like that. Definitely, because you don't want to use the wrong keyword and you end up with 80% hit ratio or something like that. You want to check those out, but you can handle that with the sample searches they have. They need something that you can do end-to-end process and not have it have it logged as well, because that's the important part. In the end, you have to have that chain of custody, but all of a sudden it stops. Okay, Discovery Mailbox, this is what it's done. Here's your chain of custody. This is a search you did, but nowhere does it say what you did with the results. So where do those PSTs come from right now? You have to write it on a piece of paper or have it in like a spreadsheet separate from your process. So that's what I would say, PSD export.
Well, let's hope Microsoft listens.
Yes, please.
We'll have to wait a while before we see whether that makes it into the next release or not. But our time's up. Thank you very much.
It's a pleasure.
It's good talking with you. For Windows IT Pro Magazine, I'm Paul Robichaux, and my guest for the last hour has been Marta Ferensbach from Sherpa Software. We've been talking about Ediscovery in Exchange 2010.